He left the way cowards always leave, without warning and without apology, with his bags already packed before the argument started, so the ending was never really in question. "I never want to see you again," Marcus said. He was standing in the hallway of the apartment they had shared for 4 years, his duffel over one shoulder, his tone carrying the particular flatness of a man who has rehearsed the words until the feeling was gone from them. "I mean that. Don't call me. Don't reach out. We're done." Grace looked at him from the kitchen doorway. She had been holding a mug of tea she hadn't drunk. She set it carefully on the counter. She looked at his face, at the deliberate blankness of it, the way he had arranged himself for this exit, and she felt something happen inside her that was not grief and not rage. It was quieter than both. It was the sensation of a door closing on something that had already been over for longer than she had admitted. "Okay," she said. He waited. She understood he was waiting for something. Tears. Protest. The performance of devastation that would confirm he had mattered as much as he believed he did. She gave him none of it. She looked at him the way you look at a problem that has resolved itself, and she said nothing else. He left. She went back to her tea. It had gone cold. She made another cup and sat at the kitchen table and opened the folder she had been working on before the argument. And she worked until 2 a.m, because that was what she did with the hard hours. She worked through them. If you have ever been told you would never be seen again by someone who had no idea what they were looking at, stay with me. Because what Grace Anand built in the 3 years after that hallway is going to rearrange the way you think about last words. Like the video right now and let me tell you everything. Grace was 32 the night Marcus left, and she had been a lawyer for 7 years. Not the kind who made noise, but the kind who made outcomes. She had spent 3 years in a public defender's office, doing work that her law school classmates called admirable, in the same tone they used for things they would never do themselves. And then 2 years at a state appellate division. And she had been, when Marcus issued his hallway pronouncement, 18 months into the judicial selection process. The judicial selection process is not something most people know about. It is long and quiet and rigorous, and it requires a record that speaks without embellishment. Years of work examined by panels of people who are not easily impressed, and who ask very specific questions about temperament, legal reasoning, and the management of pressure. Grace had begun it a year before Marcus ended things. In the particular quiet way she began most important undertakings, without announcement, without audience, without any expectation that anyone else would understand what she was building until it was finished. Marcus had never asked about it. In 4 years he had asked about her cases the way he asked about the weather, perfunctorily, briefly, with an interest that expired before she finished answering, and that she could see expiring in real time if she watched his face, which she had eventually stopped doing. He was a commercial real estate developer who understood transactions and returns and the efficient movement of capital, and he understood these things very well, and that was the precise width of his curiosity about the world. He did not understand why someone with her mind would spend it in a courtroom on behalf of people who could not pay her. He did not understand that the clients who could not pay her were the ones who needed her most, which was, she had long since concluded, the clearest possible summary of what it meant to be a lawyer rather than a businessman who had a law degree. He had suggested, on 3 separate occasions in their 4 years, that she consider moving into corporate work. She had explained, on 3 separate occasions, why she would not. He had listened in the way he listened to most things she said about work, with a patience that was really a waiting for the subject to change. She had tried, for a long time, to make him understand. She had stopped trying. She had kept working. In the 2 years after the hallway, she completed the judicial selection process. She was reviewed, evaluated, interviewed twice, and submitted to a background investigation of the sort that examines every significant decision a person has made for the previous decade. She emerged from it with a recommendation that the selecting committee described, in language that selection committees do not typically use, as essentially unanimous. She was appointed to the bench at 34. Circuit Court. The appointment ceremony was in a wood-paneled room in the courthouse on Alderman Street, and her mother was there, and two of the public defenders she had worked alongside in the early years, people who had given themselves to difficult work without glamour, and who understood exactly what this appointment meant, and her former supervising judge who had written the recommendation letter, and who had been the first person in all the years of the judicial selection process to tell Grace plainly that she had what this required. The judge held her hand for a moment after the ceremony and said simply, "This was always where you were going." Grace looked at the room, the wood paneling, her mother's face, the afternoon light through the courthouse windows. She had been building this since before she knew she was building it. In every case she had prepared as though the work itself were the point. In every moment, she had chosen the harder right thing over the easier, convenient one. She thought about Marcus once that evening, briefly. The way you think about a wrong turn that, in the end, straightened the road. She did not think about him again for 14 months, until the day his attorney filed a motion in her court. Marcus Colton, she had kept her own name throughout, which now felt clarifying in a way it had not at the time, was the named defendant in a civil fraud matter. The case was not complicated in its facts, a development deal in which the financing disclosures had been, to use the precise legal term, materially incomplete. 3 investors had lost significant money. They had filed suit. The matter had landed in her courtroom through the standard rotation of cases in the circuit. She learned this at 7:40 on a Tuesday morning, when she was reviewing the week's docket, and her law clerk, a sharp young man named Tobias, who had the specific quality of being impossible to rattle, placed the case file on her desk and said, with the careful neutrality of someone who had done his background reading, "There's a potential recusal matter on the Colton case." I flagged the connection. Grace looked at the file. She looked at the name. "Thank you," she said. She set the file beside her coffee. "I've reviewed the connection carefully. 4 years past, fully concluded. No ongoing relationship of any kind, no financial interest, and nothing I can identify that would impair impartiality in either direction. I've documented the analysis in writing. If either party believes otherwise, they're entitled to move for recusal, and I will hear that motion on its merits." Tobias nodded once, with the composure of someone who had not expected a different answer, but needed the record to show the question had been properly asked. "Plaintiff's counsel is a Daisy Mensah," he said. "She's thorough. I know her work," Grace said. She did. Adese Mensah had been 2 years ahead of her in the public defender's office, had moved into civil litigation, and had the particular quality of a lawyer who did not need theatrics because her preparation was sufficient. Grace had always found her admirable. She set the file in her reading stack. She made a note. She went on with her morning. Marcus Colton walked into her courtroom on a Wednesday at 9:15. He was wearing the suit he saved for important meetings, charcoal, well cut. The one he had worn to the closing on their second apartment, and to the evening he had said, adjusting it in the mirror, that she always made him look like someone who knew what he was doing. She had found that generous at the time. She found it clarifying now. She noticed the suit. She noticed his attorney reviewing notes at the defense table. She noticed Adese Mensah at the plaintiff's table, with her files arranged in the orderly way of a lawyer who had prepared for every contingency. She noticed nothing else that was personal. She sat on the bench and looked at the courtroom with the same even, unhurried attention she brought to every room she had occupied from this position in the last 14 months. Her clerk called the case. Marcus turned from the defense table and looked up at the bench and saw her face, and she watched what happened to his. It was brief. It was total. The professional composure came down for 3 seconds, entirely, like a power cut across a building, and then it came back up with a specific effort visible only to someone who had watched his face for 4 years and knew exactly what effort looked like on it. She gave him nothing during those seconds. Not recognition, not acknowledgement, not the smallest involuntary movement toward the personal. She looked at him the way she looked at all counsel on the first morning of a case, as a person who was about to argue in her courtroom and would be held to a standard. When the composure had settled, she said, "In the standard way, are both parties ready to proceed?" His attorney said yes. Adaize Mensah said yes. The proceeding began. Grace ran a clean courtroom. She always had. She did not favor one side or signal her thinking before she was ready to signal it. She asked questions from the bench that were precise and occasionally inconvenient, and she made no rulings she could not justify in full in writing, and she moved the case forward with the efficient, unhurried authority of someone who understood that the law was not served by drama, but by clarity. Marcus's attorney, a senior litigator named Gareth Wills, who had a very good reputation and who had clearly not been briefed on the personal history, based on the ease with which he addressed the bench, was competent and thorough. Grace engaged with his arguments seriously. She ruled against 2 of his preliminary motions, and for one, in each instance on grounds she could demonstrate were sound. On the second day, during the afternoon recess, Adaize Mensah passed her in the corridor near chambers. "You're not going to make this easy for me either," Adaize said. It was not a complaint. "No," Grace said. "I noticed you ruled against the discovery scope motion. The scope was too broad. It will come in narrower and be more useful to you for it." Adaize looked at her for a moment. The look contained a number of things, most of them professional and one of them something warmer. "I heard this was complicated," she said carefully. "It's a fraud case," Grace said. "The complexity is in the accounting records. The rest is straightforward." Adaize almost smiled. That's one way to put it. Grace went back to her chambers. She had 3 motions to review before 5 o'clock. The trial lasted 9 days. On the 7th, during the examination of a financial witness, something emerged in the testimony that required Gareth Wills to request an overnight recess to prepare a response. Grace granted it. As the courtroom cleared, Marcus stood at the defense table for a moment longer than he needed to, with the controlled stillness of a man who wants to say something and is exercising professional restraint. His attorney touched his arm. He left. Grace gathered her materials. Tobias was already at her side with the afternoon's outstanding files. She walked out of the courtroom without looking back at the empty defense table. She ruled for the plaintiffs on day 9. The opinion took her 3 evenings to write, not because the law was uncertain, but because she held herself to a standard of clarity that required every sentence to earn its place. She addressed every argument Gareth Wills had made with the full seriousness those arguments deserved, which meant that by the time she explained, without flourish, why none of them had met the required standard, the reasoning was unassailable rather than merely correct. There was a difference. She had always understood the difference. The damages award was the full amount the plaintiffs had sought. Marcus's attorney filed a notice of appeal 2 weeks later, which was expected, and which Grace noted without emotional content in the same way she noted every procedural development in a case she had decided, as a fact about the record, nothing more. The appeal was heard by a panel of 3 judges 6 months later. The panel upheld the ruling without dissent. One of the concurring opinions referenced Grace's legal reasoning with the specific, careful language that appellate courts use when they wish to signal that a lower court's analysis was not merely sound, but instructive to the broader field. She read that concurrence in her chambers on a Thursday morning with a cup of tea. She had kept the habit, the morning tea, through all the years, and she sat with it for a few minutes before she went on with her day. She thought about the hallway once more that morning. The duffel bag over one shoulder. The rehearsed blankness, the words delivered with the flat finality of a man who had decided in advance how the scene would go and had arranged himself accordingly. I never want to see you again. She thought about what he had not understood when he said it. He had said it as a conclusion, as the final jurisdiction, his last word in the matter of 4 years, and he had not understood that a conclusion requires authority, and that authority is not assumed. It is built. It is built in years of quiet work and difficult cases, and the particular kind of patient, rigorous labor that most people never see, because it happens in the hours before anyone is watching. He had not understood that she was already building the room where the rulings were hers to make. He had not thought to ask what she was building. He had not asked about the judicial selection process, or the appellate years, or the cases she considered most important, or what she thought justice actually required in practice, rather than in principle. He had never thought to ask. That was, in the end, the heart of it. Not the leaving, not the words in the hallway. The years of not asking, of standing beside someone extraordinary and never once being curious enough to turn and see what she was. She had been seen since. She was seen every day she walked into that courtroom, by the people whose cases she heard, by the clerks who worked beside her and learned from how she worked, by the lawyers who prepared differently after arguing in front of her once, because they had learned that preparation was the only thing that mattered in that room. She was seen by the record she had built, opinion by opinion, which was the most honest document that existed about what a person was. She was seen in the way that lasts, not the way that turns heads at a dinner, not the way that is pleasant and warm and forgotten by Sunday, the way that is still there in 10 years when someone pulls a case file and reads the reasoning and says, "This is how it is done." Marcus Colton had sat in her courtroom for 9 days. He had listened to his attorney argue well and lose. He had looked at her from behind that attorney's shoulder in the moments when he thought she was not looking, and she had been looking, and he had understood. She was certain of this, because she had watched his face for 4 years, and she knew its register of understanding, exactly what he had concluded in a hallway with a duffel bag and a rehearsed exit. She hoped it had been instructive. She did not require it to have been. His instruction was not her responsibility. It had never been. She picked up her next file. She began, "If this one found you somewhere true today, share it with someone who needs it. Hit subscribe. I will see you in the next one."